Good afternoon and welcome to this NZIOB webinar. My name is Malcolm Fleming, the Chief Executive of the Institute. I'm based in Greytown today, which has been impacted by a chorus network disruption this morning. I understand that could affect some of the North Island. So I'm working off my phone at the moment, rather than my newly installed fibre optic. So I'll make my welcome brief just in case it becomes a bit patchy. One of the presenters also is having some internet problems. So if we do have a problem, we have to go to finish early, we'll record the webinar and distribute. So the NZIOB is very pleased to host this third webinar on the topic of contracts. While the first two contracts webinars focused on NZS 3910, this webinar focuses on the impact that COVID-19 has had on consultancy services contracts. The NZIOB membership includes many design professionals, where we thought that this topic deserved as wide an audience as possible. So I'm pleased that the NZIA and NZIAQS have accepted the invitation to promote this webinar to their members in return for the members receiving free registration. A special welcome, therefore, for those architects and QSs who are attending an NZIOB event for the first time. As I mentioned in my welcome in the last contracts webinar, the NZIOB and Minter Ellison Rudd Watts have a good synergy in that we both represent the full spectrum of construction practitioners along with clients. For us, that representation is via our broad membership base, while for Minter Ellison Rudd Watts, it is via their clients. It is therefore important to both of us that a balanced view is presented in these forums. Today's webinar will be presented by Janine Stewart and Scott Thompson, both of whom are construction division partners at Minter Ellison Rudd Watts. Janine is also a member of the Construction Sector Accord, which is a group that has been very energetic and effective since the COVID-19 first emerged. Today's webinar will be broken down into two components. Firstly, key contract issues for alert levels 3 and 4, with a particular focus on CCCs and NZIA special conditions of contract. And 2, how can consultant standard forms of contract do better? Before I hand over to Janine and Scott, I'd like to make you aware of 2 upcoming webinars the NZIOB started development on. In keeping with the goal to provide our members and the broad industry with timely and relevant COVID-19 themed content, the topics we are addressing are, firstly, governance issues and considerations for the business owners and or directors of companies that operate in the construction industry, and another webinar on the state of the New Zealand construction supply chain. Once we have those 2 webinars framed up, we will launch them via the usual NZIOB communication conduits. Enjoy today's webinar. Please ask questions via the platform's Q&A function, which I'll be keeping an eye on. I will return after the 2 presentations to present those questions to Janine and Scott. So finally, I would like to acknowledge the support of JIB, the NZIOB's national partner, whose assistance we have been able to deliver today's event. So over to Janine and Scott.
Thanks, Malcolm, and hi everyone. And yeah, just echo Malcolm's sentiments. Janine and I thought it would be a really good opportunity to look at the issues that consultants and contractors have been facing, and that we've heard about in the media quite a lot, and spotlighting whether or not those issues are also prevalent from a consultant's perspective, and also looking for kind of those unique issues that may affect consultants as a result of COVID-19. And I know we've got two key themes on our slides, but I really think there's kind of 5 main issues that we thought we'd talk to. And the first is what your entitlements might be under those standard form contracts, and then the kind of the claims process that's associated with those entitlements, and then moving to the duty to mitigate, which has been a particular focus and issue in a number of files that we've been involved with. And then looking at kind of the most extreme situations that are arising, which relate to termination. And then finally, we thought we'd have an opportunity to speak to you about, what can we learn from all these events, and how can we take those kind of key learnings and insights forward into contracts in the future, so that we've got more fit for purpose provisions. When this arises, if this arises again, that might better work for you and for all parties in the construction chain. And before we dive into each issue, Janine and I thought it'd be a good opportunity for us to each kind of speak to some of the issues that we're hearing in the consultant world, and in particular, I'll just address two: the engineer to the contract and design consultants. And taking the design consultant perspective, and speaking with clients and other industry participants, the real issues that we're seeing relate to delay, as opposed to the major cost impacts that you'll no doubt be aware of that contractors are facing. And delays seems to be occurring for a couple of reasons. One, just the inefficiency of working at home. Even though it's possible, we all will be experiencing inefficiencies, and the issues that we've been asked about really relate to how you present those claims, because they're not as black and white, you might say, for suspension events or things like that. And the other reason that we've heard of delays is simply because the consultant's direct client, be it contractor or a principal, is withholding information, or too busy to respond, or issuing stop work orders. And so, for all sorts of reasons, I mean, it's a unique situation to be in, and it's not a criticism of anyone. It's just the issue that I've been hearing design consultants raise quite repeatedly. And then turning to the engineer to the contractor, to the contract, I certainly feel I don't envy the position that engineers to the contract are in at the moment, because it's an emotive issue, and there are certainly strong arguments on both sides for principals and for contractors. And being stuck in the middle of that is certainly a difficult situation. And we've seen examples where engineers to the contract get really well drafted submissions on change of law or suspension from principal, and then they'll get the same from the contractor. And what you'll see attached to the submissions are appendices that cite articles that have been published by lawyers or other industry participants that says the law is definitely this, the contract definitely says this. And so they're almost in a no-win situation. And I know Janine's spoken to a host of different people and probably has some insights to speak to now as well.
Thank you. I was sort of preparing for today, and I thought the term consultant is actually really broad, because it captures a lot of roles in a project, and it also captures a lot of relationships. Because, if you just list a few to start with, you've got the geotech engineer, the structural engineer, the facade engineer, you have the project manager who will be a consultant, you've got the engineer who will be a consultant, you've got the QS on the project who will be a consultant. So it captures many roles, and it also captures many relationships, because depending on the procurement model, the key design team may well sit with either the principal or the contractor, depending on whether you're dealing with a design and build or build only. And I'd be really interested for feedback in terms of how those relationships have been working in COVID-19, depending on whether you've been with a principal or a contractor, given there's been so much focus on the concepts of principal and contractor. And you may also be engaged by the subcontractor. And where your engagement sits in the hierarchy of the construction project will also impact on the consultant's cash flow. So it might be that if you're in a build-only contract and you're engaged by the principal, you have an understanding about cash flow that might be different if you were engaged by the contractor who's dependent on cash from the principal. So I can appreciate there will be many issues, and they're not all going to be similar. The feedback that I've had from one of the key consultants in the industry is that they haven't actually been focusing or concerned on claims, but they think they're coming, because they're still sort of crystallizing the impact of the lockdown period, because they've been able to work from home during that time. The biggest concern they have is around pipeline. And that's a concern that was raised at the very first Accord meeting that I attended just the day after the level 4 lockdown. And consultants are represented on the Accord, and the representative commented that much of their work can continue from home. Again, there are inefficiencies, as Scott spoke to, but he said, you know, how sensitive they are to cash flow, and how most consultant businesses are, and also that very concerned about the pipeline. So that's obviously been a concern that's been there from day one. And with the most recent conversation that I had, the concern is more in the commercial vertical space. When we've spoken to our infrastructure consultant clients, they are more confident, obviously. And also I think in the residential space, there's mixed views in terms of the role of the consultant there. And I think there are actually more residential projects that are continuing than we anticipated. But again, interested in your feedback on that. And just sort of tying out on the Accord, the emphasis has very much been on trying to issue guidance to help alleviate some of the stress that Scott was talking about for those that are administering contracts, who at least have a starting point to think about. Although there's mixed views in the market about who's right and who's wrong, I think I've certainly seen in the market the guidance note being referenced or being rebutted, but it gave a good starting point, and that was certainly the intention of the Accord. And I know that the attention now is also turning to moving away from, well, our principals being fair to contractors, to our contractors being fair to their subconsultants, and is cash moving down? So that's my feedback from the market.
Okay, and I think we might move to the next slide. And so Janine and I we'll split this up. I'll talk to the entitlements that I see that arise under CCCs, and then I'll pass back to Janine to talk about the NZIA standard form. And I think there's two direct hits under the CCCs, and there's an indirect hit. The change in law provision 12.4 and the events beyond control in 12.5 that fairly squarely fall in the COVID-19 space. And then the indirect hit really is the effects of the impact of COVID-19 by way of variations. And just to turn first to the changes in legislation provision, I'll read it briefly. So if after the date of this agreement, the cost or duration of the services alter because of changes or additions to any statute, regulation or bylaw, or requirements of any authority that has jurisdiction over any part of the works or the services, the agreed changes to cost and duration will be treated as a variation. Now that's, in my view, it's quite a broad change in law provision. It's a little different to 3910, which talks about the making of law, which I have seen commentary in the market about whether or not the health orders were making of new law. I don't see that as an argument that's quite as persuasive in the CCCS realm. What I will say is that unlike 3910, which defines cost, the reference to costs and the change in legislation provision in CCCS is obviously it's undefined, which it makes it potentially easier to put forward claims, but it also increases the likelihood of debate between the parties as to what are legitimate costs. And what the provision doesn't do is deal with what we've seen in the market is with the causation issue that's arisen as a result of this COVID-19 orders. So yeah, the argument is, well, there were orders made that made the coronavirus a part of the Health Act, but then the actual lockdown and the orders subsequent to that were people have said and argued that it's not the making of new law, but it's applying law that already existed. And with that comes the causation issue, because obviously you have to be able to show that your change in law has been the direct cause of your costs. And that is an argument that we're seeing different parties take. And I think, this is probably jumping ahead a little bit, but I think if you step back and you look at what the intent of this change in law provision is supposed to capture, in my view, it's, well, what did the situation look like at tender, or what did it look like at the time the contract was entered into? That it was what could a consultant or a contractor do at that time legally? and then a change in law happens that prevents them from doing what was legal. And I think that's the intent of these provisions, but I don't know if it's really carried through in a way that clearly captures the issue that we have here. And so I think, you know, in the future there might be some people that change these provisions to almost eliminate that causation argument. And moving towards what is really, I think it's a lot more black and white, and that's your force majeure provision in 12.5. And I think this is a really well drafted provision. It's very specific in terms of the effect, or the impact, because the result is a suspension of only those works that are affected. So it's not it's not all encompassing. And interestingly, there's another difference between this provision and 3910, and that the suspension provision here allows for time but not cost, whereas in 3910 you get both. And I think that makes sense just based on conversations I've had with consultants, and that their major concerns, at least to date, have been to do with time as opposed to cost, whereas for contractors, both are major issues. And I was interested initially when I was looking at the provision. I thought, well, this is unusual that you wouldn't get costs for a suspension. So I started looking at different contracts, and the PPP model, the standard form contracts there, they also take the same approach, in that the risk of time is with the principal, and the risk of cost is with the contractor or the subcontractor or the consultant. So it's quite a horses for courses approach, depending on the parties involved in the procurement model that's used. And then you fall into the variation regime under clause 7 if you're getting value engineering instructions, or all sorts of different instructions that may be arising as a result of the impacts or the effects of COVID-19. And I'll hand back to Janine to discuss NZIA.
Thanks, Scott. I have to say, I've only had to deal with NZIA agreement a handful of times from a dispute perspective, and it's not one we frequently use when we are drafting consultant agreements either. It's very different to CCCs in that it doesn't appear to have any sort of time mechanism in it in relation to the provision of services, the completion of services, what happens if services are delayed, etc. The closest clause that I think deals with any of the issues that we've been encountering in COVID-19 appears to be 15.3, which provides that if the agreed services need to be delayed or accelerated because of changes in the client's instructions or requirements, or due to any reasons beyond the architect's reasonable control, then irrespective of the manner in which fees are being charged, the architect shall be entitled to additional fees on a time and cost basis. So, look, I suppose there might be an argument on whether services in this time needed to be delayed or accelerated, but if that clause is triggered, it's a fairly all-encompassing clause for architects in this context. I do know from discussions with our transactional team that often NZIA is amended with numerous special conditions. So it may be that this stuff isn't included in your contract, and that there are express provisions that do deal with time, delay, things like force majeure and changes in law. But at the moment, I would say if you can get past the need definition within 15.3, it's really all-encompassing in terms of capturing any change, whether it's caused by a change of law or whether it's just caused by a standard that's introduced or not. I think another interesting part of NZIA is that if there is any dispute between the architect and the principal, the architect is able to suspend the services and is not liable for any cost or delay associated with that suspension, which again is extremely favourable to architects, and I think provides, unless it's been amended, provides architects with a lot of leverage in times where there might be contentious issues about costs and changes. And so again, that may well be changed in your contract, but it is something that's relevant to current time. I'm afraid there's not a lot more in the contract that I can
Okay.
speak to that deals with the points that you've been talking to, Scott.
Oh, okay. So I just thought it'd be one of the things that we've been asked to look at the most is the presentation of claims and advice around following processes and procedures. So often, you know, you'll all be aware that the notification provisions are typically amended, and typically they'll have time constraints and certain requirements that need to be added into a notice in order to have a valid notice. And you know, we can't stress enough that you need to follow those processes and those timeframes, because some of those provisions will operate as a condition precedent to be able to pursue a claim. And there's nothing worse than having a valid claim but losing out on a technicality. And look, that some of that comes down to the relationship between the parties and whether or not people take extremely rigid adherence to the contract at face value, or whether there's some commerciality that's afforded. And you know, we've seen kind of the full spectrum of really well articulated claims and ones that have been really poor. The well articulated claims are the ones that are issued on time, and that include all the content that's required pursuant to the notice provisions, and then adequate substantiation of the costs that are being sought, and then at the same time adding in all the mitigation steps that have been taken by that party to reduce time and cost. On the other end of the spectrum, there's some just blanket claims for unsubstantiated costs that you can't follow, they're issued out of time, and they're not even sent to the right person. And so the biggest concern that we've had raised is that, you know, if I've got a really tough notification provision, I actually don't have all the information that I need in the time I have to send it in order to be able to comply. And so, you know, my advice there is that at least address it and say, look, I note that I'm supposed to provide an updated contract program, but obviously with the events in COVID-19 and the government's changing responses, I can't actually provide a program at the moment. I'm not in a position, but at least addressing those issues and including placeholders, it goes a long way to making it really difficult for the other party to take issue with the notice. And you know, and I think the other issue that we've seen is those, I call them the waffly language in a contract, and that's not a criticism. It's just how some contracts are drafted, where it says you must promptly issue your notice, or you must issue your notice as soon as practicable. And again, we're seeing two ends of the spectrum. Some think that means, oh gosh, I need to get everything in ASAP, and they rush to do it. And others are sitting back and thinking, well, I've got all the time in the world. And what I would suggest is that the courts have given some guidance around those provisions, around those terms, and really the maximum typically afforded is 30 calendar days. I think that might not directly apply in COVID, because there is such an enormous and ever-changing impact that you need to take time. But what I always stress is, if you can get something in that does meet the bare requirements, then you should do that, and then fill in the details later, rather than having another thing to argue about, depending on your relationship. And I think, Janine, you've probably had some experience dealing with those issues as well.
Yeah, I've had recent experience where the engineer, I think the parties are looking for the engineer to guide them in terms of how they work through this process, because the contract itself has a strict condition precedent, but it doesn't appear that the parties are necessarily following it, in which case, the engineer really needs to put some structure around how these claims are going to be processed. And yes, it is in everyone's interests to resolve claims and to move forward with the project, but that just doesn't always happen, and we have to be realistic about how to deal with these matters. And so they are looking at dealing with it through the dispute process under the claims, and then the dispute process under 3910. And what we're seeing is just continued notices from the contractor saying, just so you know, there's going to be a claim about alert level 4 in relation to change of law and delay and an increase in cost. And then there'll be another one going, reminding you that we've got this claim. And then there'll be another one saying, right, so now we're in alert level 3, there's going to be another claim. But there's no analysis or even preliminary analysis, like you say, in terms of what costs are associated with that. Now, the contract requires that, and it requires it for a reason, because principals and contractors and funders need certainty about what their claims exposure is and what the ultimate cost of their project is. And so what they really need is for the engineer to put some structure around in his role as the independent to require further detail and substantiation of those claims. And I think even if there wasn't a time frame in the contract, by now in relation to alert level 4, there should at least be a preliminary indication of what those costs might look like, even with much less sophisticated contractors. I've seen claims coming in where there's a attempt that's been made along the lines of what you've said.
Yeah, and on the other end of the spectrum, you've seen some of the bigger players in the market who have taken the position that they're not going to provide a cost analysis or a contract program until they have certainty around what their program is going to look like and what their final costs have been. So it's an interesting approach, and we all have our views on that. And this leads us into the next topic, which is looking at mitigation. And obviously that's a key component and it might not be articulated specifically in your contracts, but it's a duty at common law. But in some contracts, particularly in PPP contracts, there are specific parameters around what your duty to mitigate is. And I've seen some opinions by industry participants that those contracts actually invoke a higher standard of a duty to mitigate than what's implied at common law. And Janine, I think you were going to talk to us about the principles of mitigation.
Yeah, so the principle of mitigation, how I originally dealt with it was in the context of latent defect building claims, and in examining whether plaintiffs had essentially mitigated their loss in claiming millions of dollars against council and contractors, etc. And the principle essentially provides that a party must take reasonable steps to mitigate their loss. And that would be in relation to issues such as if you had a leaky building and you were dealing with X amount of remedial work and a certain amount of that dealt with timber damage. But if the contractor was able to show that the plaintiff didn't act quickly enough in relation to the leaky building, didn't carry out enough maintenance, then they would be arguing, well, you didn't mitigate your loss, because if you had carried out maintenance, or if you had actually acted on this when you knew it was leaking, the damage wouldn't have been as bad as it was. So that's essentially around what the duty means. The duty doesn't require a party to go beyond their means to mitigate. You take your victim as you find them, so to speak. Now, it's well established that the principle of mitigation applies in construction contracts and in any contract really. And so if you are faced with a delay or a potential scope change or cost increase, then you are under an obligation to mitigate the impact of that. So it's just not a matter of it'll cost as much as it costs and it'll take as long as it takes. And that will be, for example, if you're dealing with a delay issue in relation to your services, you need to look at your program and consider whether there is a way for you to move other matters around that aren't as critical that could help you complete the project more quickly. Now, there is a line between mitigation and acceleration. Acceleration requires you to actively move the project, actively resource to move the project forward, whereas mitigation is less than that. And there are often disputes about whether you're mitigating or accelerating. Usually in construction projects and in consultant contracts, when there is a stop to the project or there's something that shuts everything down, parties look to what other projects, consultants or contractors could have sent their labour to or their materials to help mitigate the cost impact. And that's obviously different in COVID-19 because we don't have other projects on the go that you can do that with. And so it is actually quite a difficult concept to consider when you're looking at mitigation. But as I said in the first seminar, some of the points that we identified were, if you are dealing with a cash flow issue that's going to then impact subsequently on your project, have you considered the government subsidy scheme? Have you looked at your program to determine what you could do from home and what you'll need to defer to later? Have you looked at how you can mitigate the impact? Have you got anything to add to that, Scott?
Yeah, a few comments. I think the duty to mitigate is it's a difficult concept to get your head around, because while the principles might be clear, how it applies, just as you've explained, can change, and it's a real fact-based mechanic to work through. And look, the case law that I've seen, if you have acted reasonably, then your reasonable costs will be recovered. So it's so just because you're having to mitigate and it does increase your costs, as long as you can show that what you've done is reasonable and those costs are reasonable, then you will be able to be compensated for them. But as I say, the principles themselves are relatively well understood. It's the application of what the duty does on a particular case-by-case basis is really difficult. And the one that I've seen that I thought was, well, it hasn't been raised in this in this particular issue, but it's a really interesting thing to talk about in the realm of duty to mitigate, is the TG project, which there's been a lot in the press very recently. And one of the headlines was talking about contractor or the builder had sent 100 workers back offshore. And I started thinking about that while we were preparing for this presentation. I thought, well, that's an interesting one to think through, and without knowing all the facts of why it happened. You can see all sorts of different arguments being run depending on which side you take. I mean, did the party that sent those workers home, did they fail to mitigate by sending that workforce home? Or now that they know they can't get them back, have they terminated those contracts? And if they haven't, have they failed to mitigate? Have they sought to resource the contract in another way using local resource? There's so many different permutations that you can go down. And so I think, and correct me if I'm wrong, Janine, I mean, my advice would be, so long as what you're doing is reasonable, and one way of testing reasonableness is things that you've done on prior projects or things that you're hearing other participants in the market have been doing in relation to COVID. So long as there's a reasonable basis or some consistency on projects, then I think it becomes a difficult argument to say you've failed to mitigate your loss.
Yeah, I think that's a good point. You're right, though, that mitigation is fact specific. So reasonableness will be dependent on the means of the particular party. So if a contractor is, was starved of cash flow for whatever reason before COVID lockdown occurred, and they simply don't have the resources to mitigate, then that is still reasonable. And so I think it's important to bear in mind that my understanding of the duty is that you take your party as you find them. They're not required to be of a particular wealth or standing or have particular resources. You have to consider whether what they did was reasonable with reference to what was available to them. Right.
Yeah, definitely agree. And then, sorry, Janine, I don't know if I've skipped over something that you were going to talk about, but I see the next point that we have is kind of pragmatism versus contractual outcomes. Did you want to speak to that? Yeah, so
well, I think sitting on the Accord and listening to the different voices in the industry, and of course everybody agrees that we should all agree and not have to defer to lawyers. But I've probably been the busiest I have been in project disputes in quite a while. So whilst that's a great objective, and it's certainly something the Accord is going to continue to focus on, emotions are high at the moment. And so whilst in some projects the strength of the relationships have meant that parties have been able to commercially resolve matters, Others are backing into their corners and relying on their contracts. Insofar as consultants are concerned, I haven't had reports of major claims or major issues. And it may be that we're speaking to consultants who are particularly well resourced, who have good relationships with government and whose projects have kept going. And so, you know, that relationship means they're not particularly claims focused. So obviously interested in feedback on that front. From a contractual perspective, I'd say it's 50-50 in terms of whether we're having pragmatic or contract outcomes. And in many cases, there's no outcome yet.
Okay, I was going to turn to termination next, unless you had anything.
No.
Okay. So one of the biggest issues that I've been dealing with, and some of the biggest issues that I've spoken to clients about is termination, and obviously termination provisions are really inherently important in your contract because of the consequences of them. And while the termination provisions that we've been reviewing are particularly well drafted, where we're finding gaps and issues is in the analysis or the provisions that discuss the compensation sum that's payable as a result of termination. And some of the provisions is bizarre because they'll refer to terms that they could have used defined terms elsewhere from the contract, but they've chosen not to. The one I can think of is you need to pay the builder for their costs up to the termination date, and the costs term is not defined and the termination term is not defined, even though those are defined terms in the contract. And so it immediately creates a grey area and an area of debate where you wouldn't expect to see that, and so it really is quite an unusual situation where you've seen that term used consistently throughout your contracts, and then all of a sudden in the compensation sum provision, all the wording's bespoke. So we've been working through those issues. And another one, which is a client alluded me to, which is I think is a really interesting one, is what happens when you're terminated for convenience and your payment mechanic is dealt with on a milestone by milestone basis. So, for example, if you're 50% of the way through a milestone and your principal terminates for convenience, the compensation sum provisions don't deal with that scenario. So on the one foot, consultants saying, well, I've spent all this time and cost, I haven't given you any work product yet because I haven't reached my milestone, but I should be covered for that time and cost. And on the other hand, the principal will be saying, well, I don't actually have any work product for you. And it becomes it's a real challenge then to present a claim in a way that relies on the wording of your compensation sum provisions. What you end up having to do is look at the overall intent of the contract and try and tie back to the payment mechanics in order to present your claim. And thankfully for the client in particular that we were speaking with, they had a good working relationship with the principal. They wanted to preserve that relationship. And so they've worked through a commercial resolution to deal with the compensation sum, taking a pragmatic approach on the basis that, look, it's not worth dying in a ditch over some of these sums. And ultimately, if the project gets kicked off again, we'll be the party that's chosen to take that work forward. Another issue that I've been dealing with, and I really struggle with it, is the termination for force majeure. And some of the contracts that I've looked at, the termination for force majeure, you can terminate if the consequences of that event are continuing for a certain period of time. Well, so then the question is, well, what do you mean by consequences? So if you take the lockdown, for example, you have an immediate event, you can kind of crystallize how long the lockdown was for, but what are the consequences continuing as soon as the lockdown comes to an end? Well, we don't really know what the contract means by consequences. Does it mean all of the consequences? Does it mean material consequences, or can it just be one consequence that's flowing from the lockdown? And I raise it as an issue, and one that I'm really struggling with myself, because there's huge ramifications, especially on big projects, because if you think you're entitled to terminate, but it's a grey area, and you do so, and the other party says, no, you didn't have a right to terminate, then you've necessarily walked into a repudiation claim, and those, I mean, those are nasty, and there's all sorts of liability that can attract. So, you know, this is kind of jumping forward a bit to our last topic, which is looking at, you know, how you might change your contract provisions in the future. But you know, for fundamentally important provisions like that, we really do need to take a step back and look as a, you know, as a profession and as an industry on how we can, you know, try and decrease the grey areas and make things a little more black and white. Now, you know, if we had the magic bullet for that, we would have already done it. But you know, I think the trouble with some of these provisions, and Janine, you'll have your own views as well, is that a lot of the time when you're negotiating your contracts, it's the same provisions that come up time and time again that you'll negotiate. And there's, you know, there'd be a whole range of provisions, your boilerplate ones and the ones that you never really use, that kind of just get carried over from deal after deal after deal. And so when it comes time to actually have to rely on them, the drafted intent is really not that well understood by the parties, because the language has come from, you know, 10 years ago, 20 years ago. This was something when I was practicing overseas, you know, and most of my career has been drafting contracts. You'd sit back and you'd think, hang on a sec, I don't know what half these provisions mean. Can someone talk me through them? And everyone says, oh yeah, such and such drafted that 20 years ago. We thought it was good and we've still got it in there. So I think, you know, especially with the termination provisions, it's been a real difficulty both for clients and for lawyers to come to firm positions, and it's frustrating for clients because they want to know what their hard and fast rights are, and it's frustrating for us because we'd love to be able to back ourselves 100% and say, you know, this is definitely the position. And yeah, so that's one of my issues. Janine, do you have anything to add to that?
I don't have a huge amount on termination, other than I agree that the clauses are complicated, and more often than not, I have become involved in representing a party to a dispute who has tried to terminate a contract pursuant to a clause and is in litigation. I think, just reflecting on some of the work that I've done over the last while, where there was a termination for convenience clause, albeit there needs to be some tidying up, as you've mentioned, I do think they can be helpful. And when you look at our current situation, I think in some of the projects that I've been involved in, it would have been helpful to have a termination for convenience clause in there. I know the New Zealand market has been reluctant to embrace the termination for convenience in some cases because it's such a draconian consequence. But so long as you are able to negotiate a commercial outcome for the contractor that they're comfortable with, then it's definitely something that should be explored. When you look at some of the cases that I've seen it utilised is when the government changed and projects were uncertain, and neither the principal or the contractor necessarily wanted to be tied to the contract that they'd signed or each other. And I think in those cases, the termination for convenience clause could be well utilised, and then the parties are able to start again. Now, I know in many cases that's the worst outcome for parties, but in some it isn't. And I'm also following the Wellington earthquakes. So in that case, I could see the benefit of
I think we might have lost Janine there. Okay, yeah, I think Janine's connection was a bit funky before we started, so I'll just try and take that forward and kind of wrap up. Yeah, and what I was saying before, it's not a criticism of contract drafters. It's just one of those things where you haven't experienced the issue before. It's really hard to try and draft for every possible outcome. And I think the way forward from here, really, it needs to be a partnership between, you know, your in-house legal team or your external legal team and your business team that's been dealing with these issues within your contracts, because everyone will have different experiences, and you know, you won't engage your external lawyers for everything. And so, we only see a handful of the issues, but you'll see all of them. And so what I think, and you'll be able to know what has worked and what hasn't worked. And so I think taking things forward, that once the dust settles, I think it would be really helpful for everyone to work together to discuss what worked and what didn't in your contracts, and how we might better protect and make more fit for purpose provisions in the future arising out of COVID, in case these sorts of things happen again. And so, in terms of specific changes to contracts, look, I touched on the CCCs, the changes in law provision, where you might try and capture the intent of that provision a little more in a more detailed way, so that you could remove the issue of causation, and at the same time, perhaps it'd be useful to define what we mean by costs. I think, as I said before, one of the areas that I struggle with, and I see our clients struggling with all the time, is this duty to mitigate. And one of the ideas that's been floated is perhaps attaching a guidelines to your contract that just sets out what the general principle, what do we mean by duty to mitigate, and what the principles are, and what are the types of examples that you would have for mitigation. And then on the payment side of things, that's another area where you could put some parameters around the types of costs, and you could do it as a schedule, like the types of costs that might be recoverable for these sorts of events, and who shares those costs, because I know that's a huge area of contention. And is it time to sit back and think, reassess risk allocation, because ultimately this is an issue that's not anyone's fault. And what you want ultimately is a successful project, and you want everyone in the project chain to come away in the best shape possible. And so fairness becomes a really difficult thing to capture in these contracts, but I am really encouraged to see our clients and other parties taking these commercial and pragmatic approaches, and it would be great to see how we can carry forward those types of arrangements into our contracts, so that the next time that something like this happens, we've got a framework that we can already work with, and we know it worked, and it benefited everybody, or it risk shared in a way that left everybody with the best bargain possible, really. Are you back, Janine?
Yes. Yep.
Okay, so I was just giving some commentary around how I think contracts could move in the future. I don't know how much of it you heard or not.
Yeah, I heard you.
Okay.
I agree. Yeah.
Yeah. So if there's anything else that you wanted to add, please feel free. Otherwise, we can do questions.
I just say it's been very much about should they be the principal's cost, or should they be the contractor's cost? Should they be the client's cost, or should they be the consultant's cost? And I agree with you. If we could establish a cost sharing outcome that meant parties could resolve it quickly and move on with the project, that would be ideal.
Okay, thank you. Malcolm, I think that's all the content that Janine and I were going to cover. So if there are questions that we can try and answer, we'd be happy to.
Yeah, thanks very much, Scott, and thank you, Janine. We've got a question here. Where your commentary regarding reasonable costs, I assume you are talking of an unforeseen event, in which case, would this then redefine 10.3.1F?
Oh, are we talking about 3910 here?
Yes, that's 3910 clause. Yeah.
3910? Okay.
Yeah.
I'm not quite sure if I made that comment or you made that comment, Janine.
Well, I think if what you're asking me is if we are going to allocate cost for unforeseeable events, then we need to consider a cost sharing arrangement. Well, yes, that would require amending 3910. But I think what Scott was, when we were talking about risk sharing and we're looking at change of law and who should bear those costs, for example, I think that clause would also require some amendment because you're not just looking at amending clauses that presently only favour principals, but you'd also be amending the clauses which would give the contractor costs. So you'd have to adopt a consistent and balanced approach throughout the contract. I think in 3910 we couldn't just deal with one specific clause, we'd have to look at it holistically.
Yeah, that's right. And actually, there's a really helpful article that I read. It was a QS outfit that put it together. But one of the themes that was in that paper discussed, is it fair for the contractor to miss out on its costs, and is it fair for all of its costs, and is it fair for the principal to pay all the contractor's costs and profit? So perhaps one of the things that you might look at is okay, contractor can recover its costs, but does it recover profit in that situation when the event is no one's cause? Perhaps that's one thing to look at. And I'm sorry, I can't remember the name of the outfit that put it together, but it was a really useful piece of guidance. I really enjoyed reading it.
Yeah, well, potentially the QS practice in question is probably on this webinar, so they might be able to jump on the Q&A and let us know who it is. I was really interested, Scott, you're talking about you personally were encouraged to see a lot of pragmatic approaches being taken by a number of parties, consultants, contractors, and principals, the clients, which is good. I was really interested in that whole risk sharing. Is it time to start re-looking at some of these contracts in terms of a risk sharing? Probably, Janine, is that something that's been discussed at the construction sector accord, risk sharing and contracts going forward?
Yes, and it's a work stream that is on the Accord's agenda. So the Accord has a broad transformation plan that has a number of work streams. Some are government-led, some are industry-led, and some are shared. And one of the work streams is balanced risk allocation. And the start of that was to change the procurement rules last year, and it's an ongoing work stream. So that work stream was paused in the face of the need for a COVID response team, but the first meeting today is on referring back to the transformation plan, so that will be on the agenda.
That's great. It's really good, Janine, having that sort of tie-in with the Accord through these webinars. Rawlinsons, yes. I've been told, two people have told us, Rawlinsons is the breakfast. Shout out to Rawlinsons.
Yeah, big shout out to Rawlinsons. That was a really helpful industry article. I learned a lot because, as a external counsel, you see how these provisions are drafted, but you don't always see the claims that are submitted. So it's really helpful to understand, the QS role and how QS thinks about going through performing those functions when we don't see that on the day-to-day. So I found that really useful. That's
great. All right, we're getting close to time. 1 o'clock, people want to get away and listen to the latest COVID-19 update from the government. I've got no further questions in there, unless one materialises in the next 30 seconds or so. Any final wrap-up, Scott and Janine?
No, sorry. I was just going to say it's there's been so much discussion about principals and contractors and are they being pragmatic? Are they looking at the viability of the contract? There's been a shift now to looking at whether subcontractors are treated fairly. And I'm just really interested in, and so has Scott, your feedback in terms of some of the issues that you've been dealing with. We've obviously covered some, but interested to know whether they are ones that are impacting you and whether there's anything else that you would want more information on.
Yeah, I'd echo that. I think it's a really interesting area to be involved with, and it impacts so many different aspects of the construction chain and all the contracts that go with that. And as I said before, I think it's really important to have that conversation, just not in a vacuum, but between everyone. And so I'd be more than happy to take this offline with other people and share views and any other insights, and also speak to anything else in the future that you think hasn't been covered and that needs some real leadership in terms of discussing amongst the industry.
Okay, that's great. Just a little final flurry of questions in here. Someone's asking, do you think there'll be a 3910 amendment? One
I
for
think
you.
there's one in the works before. They've been working on one for a while, haven't they, Janine?
Yes, and I'm just seeing I'm just reading through some of the questions about whether government departments are going back to costs being the basis of awarding contracts. I am aware that they have made changes to the procurement rules that were introduced last year, particularly in the face of COVID-19 to try and speed projects up. I'm not sure I would phrase it as you have there, Dan, but yes, all I'd have to say is risk allocation is a big item on the agenda, and I'm sure 3910 will fall into that as well. Although my understanding is from a lot of contractors, they didn't before this outbreak see a great need to amend 3910, so it'll be interesting to see whether they do now.
That's great. All right, that looks like a wrap. So once again, thank you, Scott and Janine, and I hope the architects and QSs who attended their first NZIOB webinar enjoyed it. And that looks like us. We've got a couple of minutes to spare to turn on the wireless.
Great, thank you.
Yeah, thanks.
Okay, thanks very much.
Bye.
Bye.